I will now call this meeting to order of the Senate Judiciary Committee on April 2nd of 2021. Would the Secretary please take the roll?
Vice Chair Cannizzaro.
Here.
Senator Orenshaw.
Here.
Senator Harris.
Here.
Senator Settlemyre.
Here.
Senator Hansen. Senator Pickard.
Here.
Chair Scheibel.
Here. And for the record, Senator Hansen is also here. I'm not sure if you could hear him or not. I couldn't.
I'm here.
So that means that everybody...
My apologies. I am here. Thank you, Chair.
We'll forgive you this time. And with that, we are ready to get this meeting started. We're going to take the work session first while we have everybody. We have two bills on work session today. The work session document was uploaded earlier. And I think we are ready to dive in. I'm sorry. We do have Mr. Guinan, Patrick Guinan and Nicholas Anthony with us from LCB today. If the record could please reflect their presence. And with that, I would like to move on to the work session. Mr. Guinan.
Okay, thanks, Chair Scheibel. This is Patrick Guinan for the record. I'm the committee policy analyst. As the chair mentioned, we have two bills today. The first one is SB 108, which is a committee bill brought on behalf of the Nevada Youth Legislature that this committee heard on March 16th. And Senate Bill 108 requires persons employed in the criminal justice system in Nevada to complete at least once every 2 years training and instruction relating to implicit bias and cultural competency. And it also requires the Attorney General to adopt regulations concerning training in those areas. And the bill also requires that any person who files a court petition must commence a juvenile proceeding, must file an affidavit certifying that every person involved in the decision to file the petition and who is required to complete such training has done so, and that the petition is not being filed as the result of any inappropriate discrimination on the basis of any protected class or characteristic. And a court is prohibited from accepting any petition to commence a proceeding that is not accompanied by such an affidavit. In response to some concerns voiced during initial hearing and in consultation with several stakeholders, the sponsors have proposed an amendment which is attached on the following page. That amendment narrows the scope of the bill to the juvenile justice system and those who have routine contact with juveniles within the scope of their employment, including employees of regional facilities for treatment and rehabilitation. The amendment also provides that the responsibility for developing regulations and requiring training in implicit bias and cultural competency will rest with the Division of Child and Family Services of the Department of Health and Human Services rather than with the Attorney General, and that responsibility for providing the training will fall to an individual's employer. The impact of trauma and adverse childhood experiences on decision-making and behaviors is added to the list of information that must be included in the training provided, and the Nevada Supreme Court is authorized to provide by rule for appropriate training for any magistrate, judge, master, or employee in the juvenile court system who routinely interacts with system-involved juveniles. And finally, the amendment provides that the portions of the bill requiring training are effective 9 months after the adoption of the regulations developed by DCFS. And that's the sum of the amendment. Chair Scheibel and I believe Mr. McCormick from the Administrative Office of the Courts is with us today to answer any questions the committee may have, as I believe he assisted in drafting the amendment. And that's all I have. Thanks.
Thank you. It looks like Senator Pickard has a question. Go ahead.
I do. I was able to reach out to, after seeing the amendment, to representative from JJS. They said this is already in place. I was not able to, however, to get a hold of any of the judges. I'm wondering if Mr. McCormick can tell us if this is already in place for the judicial officers.
Excuse me. Thank you, Senator Pickard. John McCormick for the record. We are currently actually in process of delivering training in this area to all the district court judges in the state, and that'll happen on May 25th, I believe. and it'll be part of our ongoing training regime going forward.
And will that also apply to the masters?
Masters will have opportunity to catch up with that later on after we post it on our distance education website.
All right, perfect. Thank you. And thank you, Madam Chair. It looks like the bill is technically unnecessary because it's already there, so I have no problem supporting it.
Great. And Senator Hansen.
Thanks, Matt. My take's quite different, frankly. I didn't bring up anything during the hearing because the youth legislators were bringing it. I didn't feel comfortable challenging a bunch of teenagers. But there was a bunch of statements in there that really disturbed me, and I want to get them on the record now. One, Trayvon Martin was not murdered. In fact, George Zimmerman was acquitted. And when the civil rights aspects of it were brought up, the Department of Justice actually dismissed that entirely. So the very premise that kids started with was wrong. The other thing is this whole bias training. I've been working with these juvenile justice people for 6 sessions now, and I know nobody in this state, frankly, that cares more about all juveniles of all races and colors than people like Bridget Duffy, okay? So this concept of implicit bias in the system is biased itself. I mean, the version of American history that these people are looking at is basically the Howard Zinn version. You know, where essentially everything that's bad is all we focus on, and we completely suppress any of the positive things that have occurred in American history. And the idea that we're going to force all the people in the criminal justice system every 2 years to go through basically a reindoctrination program is just wrong. And it's based on a false premise that there's a systemic problem in the system, which I totally 100% reject after years of personal observation. So I just want to get that on the record because I didn't want to back when the kids were doing their presentation. I wouldn't be comfortable with that. But I do want to know why I'm voting no today, because I reject the concept that the criminal justice system in Nevada has an implicit bias. And in fact, I think the people that are pushing the bias training are the ones with the bias. So just wanted to get that on the record. Thank you, Chair.
Noted for the record. Any other questions on SB 108? Not seeing any, I will accept a motion to amend and do pass.
So moved, Chair.
We have a motion from Senator Orenshaw, seconded by Senator Harris. Any discussion on the motion? Not seeing any, we will move to a roll call vote, please.
Vice Chair Cannizzaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre.
Yes.
I'm sorry, I didn't understand that.
Yes.
Thank you. Senator Hansen,
No.
Senator Pickard,
Yes.
Chair Scheibel.
Yes, and with that, the motion to amend and do pass carries. Is there somebody who would like to take the floor statement? Senator Harris, the floor statement is yours. And that concludes our work session on SB 108 and takes us to our work session on SB 212. Mr. Guinan.
Thanks again, Chair Scheibel, Patrick Guinan for the record. We're now on Senate Bill 212, which is a bill sponsored by Senator Harris, who is a member of this committee. We heard it on March 25th. Senate Bill 212 prohibits the use of restraint chairs by law enforcement and also prohibits a peace officer who is responding to a protest or demonstration from discharging a kinetic energy projectile indiscriminately into a crowd or targeting the head, pelvis, or back of a person. Prior to using a chemical agent, an officer must first declare that the protest or demonstration constitutes an unlawful assembly, provide orders to disperse, an egress route, and reasonable time to disperse. The bill requires a peace officer to employ de-escalation techniques and other alternatives consistent with his or her training before resorting to higher levels of force to effect an arrest. If an officer uses a higher level of force, the officer is to identify himself or herself if this can be done safely, and is to use the objectively reasonable amount of force only, the objectively reasonable amount of force necessary to safely accomplish a lawful purpose. Law enforcement agencies are required to adopt written policies on the threat posed by certain persons to peace officers and others, and are required to report data on the use of force to the Attorney General, who is required to review the data and report the findings to the Governor and the Legislature. Law enforcement agencies are required to participate in the National Use of Force Data Collection Program of the Federal Bureau of Investigation. The data collected may not be used against a peace officer during any criminal proceeding. After the initial hearing on the bill, Senator Harris put together a new amendment, which is proposed today and which is attached to the following page of this document. Briefly, the proposed amendment removes references to the Attorney General from the bill regarding law enforcement agencies reporting use of force data and replaces those with appropriate references to the Central Repository for the Nevada Records of Criminal History. It removes the prohibition on the use of restraint chairs in Section 4 and instead places restrictions on their use and procedures to be followed both before and during the use of a restraint chair. And it removes language concerning a peace officer aiming at a person's back and instead inserts spine or other vital areas of the body of a person in place of the word back. And that's all I have, or Chair Scheibel, excuse me.
Thank you, Mr. Guinan. Any questions on this bill? I am not seeing any questions, so I would accept a motion to amend and do pass.
So moved, Chair.
We have a motion from Senator Orenshaw. Is there a second?
Second.
And a second from Majority Leader Cannizzaro. Any discussion on the motion? Senator Hansen, go ahead.
Madam Chair, thank you again. Same issue. I think the police are already doing most of this. I think that once again, we're attacking the good guys. We're trying to handcuff our police. I think that when you study these issues, particularly the case, when we mention people shooting randomly into crowds, we seem to forget that we had a police officer that was shot in the back of the head. Can't think of his first name, of Michelanis, in the very incidents that raised this, that we haven't even said boo about. I think we're once again going after the good guys and using this bias training, false philosophy to further handicap the ability of our law enforcement officers to do their job. I think they already do everything reasonably under the sun to try to keep this sort of stuff in check. When you see the 1.3 million instances that the police officers in Clark County, for example, did in 1 year, and the tiny sliver of issues that they have, this sort of legislation is wrong, and I'm voting no. Thank you.
Duly noted. Senator Pickard.
Thank you, Madam Chair. Along that same vein, I think that with the amendment, it just more solidly places this in the position that law enforcement already finds themselves. They're already doing most of these things. I think as a result, and particularly given the presentation and the testimony that we received, I think this is an affront to police. It's completely unnecessary, and I just cannot support this kind of action. Police react to what they find. They don't create the problems. And say what you will about implicit bias, I think they do everything in their power to address those things. And I think we should be ashamed for bringing this kind of bill. I'll be a no.
Also duly noted for the record. Any other discussion on the motion? Majority Leader Cannizzaro.
Thank you, Chair Scheibel. I wanted to just thank again Senator Harris for the amendment here and for bringing this bill forward. I, again, as someone who has worked in law enforcement for nearly a decade and who works with officers every single day, prosecuting violent crimes and working with those officers who I know do a really fantastic job and take a lot of pride in their work. I think uniformly saying in our statutes that there should be de-escalation techniques, which we know a lot of good police departments in our state are employing, that allow them to safely respond to situations. I don't see anything in this bill that would prevent an officer in the event of being in a situation where somebody's life was at danger, where their life was at danger, from using deadly force if that was what the situation called for, but also putting in there some parameters to our community to say, you know, when you are calling and it's not that situation, you don't have to be fearful of the police. I think we're giving them the appropriate mechanisms, and I think we're creating the right kind of accountability. So for me, the fact that we are doing some of these things already creating uniformity across the board makes a lot of sense. And I think that this is something that actually gives some direction and some guidelines for law enforcement, which is always helpful. And again, we have a lot of really great men and women in uniform who do a wonderful job. I'm always proud to work with them in my day job. And I think that this helps to ensure that the community can have that same kind of confidence in the job that they do every day. So I will be supporting the bill and the amendment. Thank you, Chair.
Thank you. Senator Settlemeyer.
Thank you, Madam Chair. I believe that the law enforcement, the vast overwhelming majority of them are great people and doing great things. Sadly, like in all professions, sometimes there are a few bad actors. And I really wish we could find a way to target those bad actors rather than legislation that potentially is burdensome for those individuals that are already doing great jobs. As we've heard, most departments are doing this already, but I think each department is different. I think every aspect of our state in that respect can be quite different. Some of the smaller sheriff's departments may find these type of rules burdensome. So in that respect, I just necessarily can't endorse it at this time, this type of a concept, especially in light of the testimony. When we have individuals that come into this body and blatantly fabricate data, we should not support it. Thank you.
All right, and I will take a personal point of privilege to echo the Vice Chair and Majority Leader's comments that I also work in law enforcement and with police officers every single day who support this bill. And we heard at the hearing that multiple law enforcement agencies in the state had worked very hard with Senator Harris to get to this amendment. And I think that looking at it not through a broad lens of who's at fault and who did what, but looking very pointedly at the language of the bill, it does exactly what we're supposed to do as lawmakers, which is ensure to every citizen of Nevada that they are ensured certain rights and certain safety, especially when it comes to the use of force. It's not overly burdensome. It matches Metro's current policy, and the use of force, frankly, should not be different across law enforcement agencies. People in Nevada should know that wherever they go in Nevada, even if they are committing a crime or suspected of committing a crime, they should know that they're going to be approached and responded to with respect and dignity and a reasonableness that doesn't put them in fear of serious bodily harm or death. I agree with the Majority Leader that that is what our officers do every day. They respond in a reasonable fashion. They respond with respect, and they uphold the safety and the laws of the state of Nevada. And we are simply putting that into statute so that there is no question about what that means and how that is supposed to be done. I'm proud to support this bill. I'll also be a yes. And with that, Secretary, I ask that we move to a roll call vote.
Vice Chair Cannizzaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemeyer,
No.
Senator Hansen,
No.
Senator Pickard, I'm sorry, Senator, I didn't hear you.
No.
Chair Scheibel,
Yes. And with that, the motion carries to amend and do pass SB 212. And I will assign the floor statement to Senator Harris.
Madam Chair,
Yes, Senator Hansen.
the young officer's name, I want to get on the record for 108, for SB 108. Shay Michelanis, 29 years old, shot in the back of the head by one of the protesters, and who is paralyzed from the neck down. Thank you, Madam Chair.
Understood. With that, we will close the work sessions. That leads us to our bill presentation from our very own Majority Leader and Vice Chair. I have to present a bill in another committee, so I'm going to hand the gavel over to the very capable Chair Orenshaw to conduct this hearing in my absence, but I hope to be back before you're finished. Thank you.
Thank you, Chair Scheibel. I will now open the hearing on Senate Bill 219, and we are very lucky to have Senator Canizaro, our Majority Leader, here to present Senate Bill 219. Thank you for being here today, Majority Leader.
Thank you, Chair Orenshaw, members of the committee. It is my pleasure to be here in front of the Judiciary Committee, being able to present a bill, one of my favorite committees in the legislature, which I think is a secret to no one. Thank you again for having me. For the record, my name is Nicole Canizaro. I am the senator from Senate District 6 in the northwest portion of the Las Vegas Valley, and I am coming before you today to present to you Senate Bill 219, which removes provisions to suspend driver's licenses based on inability to pay court-imposed fines and fees. I am joined today with me, members of the committee, by Lisa Mosley, who is the Nevada State Director for the Fines and Fees Justice Center. I'm going to give a brief presentation on the bill and walk through some of the sections of it, and then I'm going to turn it over to Ms. Mosley, who I think can provide some additional contextual data behind the reasons for this bill and why I believe that this is a good piece of legislation. By way of background information, for those of you who are not readily familiar with how courts handle fines and fees, today, driver's license suspensions are a frequently used tool to enforce the collection of what I will refer to as criminal justice debt. And that refers to the accumulation of fees and fines that a defendant acquires while being processed through the justice system. These fees and fines can be imposed as administrative fees. They can be fines for offenses that are tied as part of a sentence when someone is not serving time in custody, and may be a condition for them to fulfill their out-of-custody obligations after having pled guilty to a criminal offense. They can also be imposed after someone is found guilty of a criminal offense as part of regular fees and fines that are assessed, and then, of course, anything that comes as a result of their sentence. These are often used to prevent, to act as a deterrent from future wrongdoing, but they're also imposed as administrative assessments on defendants. When combined with other costs of living, of course, these can sometimes fall by the wayside. We think of rent and mortgage payments, credit card debt, insurance payments, child support, other things that come as a result of daily life, and the additional cost of criminal justice debt can be difficult or impossible to pay. One estimate by the United States Census Bureau in 2012 puts fees and fines collected by state and local governments at more than $15 billion per year, and this is a chunk of that. This is when collection enforcement, such as suspension of a driver's license, is introduced. When people lose their driver's license, they of course also often lose their job or have trouble finding work, and therefore are unable to satisfy the debt. Because people need to drive to go to work, to get to a doctor's appointment, or to provide transportation to their children, they often drive on a suspended license, despite the fact that it has been suspended. If they are stopped by law enforcement, of course, that results in another charge for driving on a suspended license, which is a traffic citation, and also may then incur additional fines and fees as a result of having driven on that suspended license. The resulting cycle of debt and prolonged criminal justice system involvement disproportionately also burdens low-income communities. Now, I want to be clear that fines and fees are one way in which we may assess individuals a particular punishment for having committed a particular crime because they pled guilty, because they were found guilty. This can also include things like community service, stay out of trouble orders. Sometimes they have to do additional counseling, those types of things. And we're not saying in this bill, and I want to be clear about that courts couldn't assess fines or fees for criminal involvement, be that for traffic citations or for misdemeanor events. But what we are saying is that when it is strictly an inability to pay, so not someone who is out committing additional crimes, who are violating these orders, who aren't doing the other things that we ask of them while they are out of custody and completing their out of custody sentences, or who are just frankly unable to pay those fines and fees, that what we're not trying to do is impose yet another reason for them to continue to incur fines and fees, and also take away one of the main ways in which an individual may be able to actually pay back those fines and fees, by being able to drive to work, by being able to gain employment and to come back to court and to fulfill those obligations. I think that there are other ways that we can ensure that people are taking responsibility for their actions, and also ways in which we can ensure the safety of the community that don't result in this never-ending cycle of debt. And that's what Senate Bill 219 is seeking to get at. It is an effort to curb that same cycle of debt that can sometimes be acquired and reduce the burden on court dockets as well. This bill aims to stop the suspension of a driver's license based on an individual's inability to pay. Section 1 of this bill removes the authority of a court to suspend a driver's license of a defendant or prevent a defendant from applying for a driver's license. When Senate Bill 219 goes into effect, according to the language that we have in the bill, on October 1st of 2021, Section 4 would require that the Nevada Department of Motor Vehicles immediately reinstate a driver's license or the ability to apply for a driver's license for individuals subject to a suspension of their driver's license because of delinquent fines and fees. Section 4 also states the DMV cannot charge fees for reinstatement of a driver's license or require a defendant to undergo any physical or mental assessment for eligibility purposes. There's been similar legislation introduced in several states to include North Carolina, Tennessee, Virginia, Mississippi, Montana, and New York. That eliminates the practice of suspending or revoking driver's licenses simply for unpaid court-imposed fines and fees. I have had some conversations with stakeholders, and I would note for the committee that those conversations are still ongoing. I did have an opportunity to sit down with representatives from the Department of Motor Vehicles to further discuss, and while I understand this is not a fiscal committee, but certainly we wanted to have a conversation about the impact to the Department of Motor Vehicles and their ability to comply with the provisions of this bill as well. And while there did not seem to be any objections to the policy overall, we did have an opportunity to have a discussion about some of the fiscal impact that would occur to the department. And we are currently working with them to get a few more numbers on how many people really fall under this category of having suspension, not because of any parameters regarding, for example, DUIs or other reasons why you may have a driver's license suspended, say you have too many points or there are other impositions on a driver's privilege that would result in suspension, but where it really is just due to these fines and fees that are outstanding from a court. And they're going to thankfully, and I'm very grateful for, delve into some of those numbers to get a better idea of what that is. I'm very grateful to the representatives from the Department of Motor Vehicles, who I know have had a really tough job over the course of this pandemic and have done a wonderful job of helping to keep everybody on track. And so I know that they need just a bit more time to kind of work through some of those. And so that is an ongoing process as well. And I'm thankful for them coming to the table to work with me on that. I also had an opportunity to speak with some of the judges of limited jurisdiction as well, and they addressed some concerns that they have over the ability for a court to have discretion over when to suspend a driver's license, because under the current law as well, this is not something that is discretionary for the courts. It's something that sort of uniformly happens. And so I think giving discretion is certainly something that it was an important piece to discuss. And also we discussed the implications of this bill in addition to another bill over in the Assembly being carried by Assemblywoman Wynn that deals with the transfer of traffic tickets to civil infractions and the interplay between these two bills to ensure that we can still, get our fines and fees for traffic tickets, but not inadvertently either suspend our driver's licenses or turn those into criminal infractions, and how those two things would work together. So we're still working on the language there to make sure that this can be a tool that can be used in conjunction with that bill and how the interplay would work. That is an amendment that I would anticipate as we get a little further towards our deadlines in committee that we can hope to ferret out so that it makes sense in accordance with that bill as well. In addition, I wanted to, again, have an opportunity to just thank the committee and reiterate the point that driver's license suspension really does nothing for public safety in the broad sense, and it creates unnecessary burdens on the courts with defendants who are just simply guilty of driving while poor, right? They can't pay those fines and fees, and now we're imposing additional ones. I'm hoping that we will gain some support for Senate Bill 219 as we strive for a more equitable and fair administration of justice. Mr. Chair, I would like to, at this point, turn it over to Ms. Mosley to talk a little bit more about what the impact is of these kinds of laws that help to sort of further that continued cycle that I discussed earlier, if that would be okay with the committee.
Certainly, Majority Leader. And I see, good afternoon, Ms. Mosley. Good to see you. And I'll take questions after your presentation. So please be patient, Senator Hansen. Thank you. Thanks for joining us.
Well, good afternoon, Chair Orenshaw and committee members. And I am Lisa Mosley, State Director for the Fines and Fees Justice Center, Nevada State Director for the Fines and Fees Justice Center. And first, I want to just thank the Majority Leader, Madam Nicole Canizaro, for extending an opportunity to me to co-present this bill with her. This legislation is something that is very close to my heart, not only in my capacity as the State Director for the Fines and Fees Justice Center, but also in a personal capacity, as I myself have been affected by this practice in the past, and have many people that are close to me that have also been affected by the practice of getting their license suspended for debt-based for outstanding fines and fees, I should say. Forgive me, I'm a little nervous about this. I want to talk a little bit about who this affects. Now, Madam Majority Leader did talk a little bit about minority communities, but I also want to just highlight who this affects, and also, as she mentioned, provide some additional data on other states that have ended this practice, and also how this practice affects residents of the state. So we know that debt-based driver license suspensions disproportionately impact communities of color, particularly Black and Hispanic communities. These communities are more likely to be the subject of law enforcement interactions and have their licenses suspended. In 2015, our own review journal investigated this practice, and they looked at law enforcement data and found that residents living in some of the 7 poorest communities, communities that are statistically African American and Hispanic, that accounted for nearly 2/3 of traffic citations. Now, many of these citations result in these residents getting their driver's license suspended simply because they cannot afford to pay the fines and fees that come with that. This is a practice that just traps people in a cycle of poverty, and it's nearly impossible to get out of. It's a practice that suspending for outstanding traffic debt, it's premised, I should say, on the belief that people who have outstanding debt just simply don't want to pay, like they're scofflaws, they just don't want to pay. But the data that we have does not support that. It shows that people, it's not about a willingness to pay, but people simply are unable to pay some of the high fines and fees that come with traffic violations. Now, I did mention earlier that some of the zip codes that have the highest concentration of Black and brown people, these are also some of the zip codes that have some of the highest rates of food insecurity and unemployment. So, there's no coincidence here that these are also the zip codes that have the highest numbers of citations and driver's license suspensions. I want to, just for emphasis, I want to talk about New York for a moment. And the reason I want to talk about New York is because New York recently passed legislation similar to what we're trying to do. This also just highlights the disproportionality in which this practice affects mostly Black and Hispanic communities. In New York, the 10 zip codes that had the highest concentration of Black and brown people had 4 times the suspension rates of zip codes that had higher concentrations of non-Black and brown residents, in other words, white residents. In New York, where 76% of the drivers are white, 80% of the people that were arrested for driving on a suspended license were either Black or Hispanic. And in those zip codes that I mentioned in New York, the suspension rates for Black and brown people were 9 times higher in those zip codes than in wealthier white zip codes. I also want to just paint a picture of the number of suspensions that we see here in Nevada. Between July 2017 and June of 2019, data that we have from the DMV here show that over 38,000 Nevadans had their license suspended for unpaid traffic fines and fees. They had their license suspended simply because they were not able to pay outstanding fines and fees. And the research that we have shows that it doesn't make it easier. States don't collect some of this money. It makes it harder, in fact, for people who have their licenses suspended. It presents them with an impossible choice. They either stop driving and lose the ability to take their children to work, take families to doctor's appointments and things like that, or keep driving and risk the possibility of getting more fines and fees, getting arrested, and even incarcerated, which we have seen that happen in many cases. And for the most part, it doesn't result in people actually paying their court debt. We do have data that shows that in jurisdictions, in states that have stopped suspending, collection rates have actually gone up. For example, in California, and I know we don't always like to use California here in Nevada, but they've stopped this practice and they have some really great data that came out of that. So for example, in California, when they stopped suspending licenses for unpaid traffic debt, their one-time payments actually increased by 8.9%. Now, we also know that there have been some concerns from jurisdictions about what's going to happen with their revenue. Are they going to see their revenue decrease? But in San Francisco, when they stopped suspending licenses, they actually saw an increase in their revenue as a result of not suspending driver's license in the year when they stopped that practice. Now, another good example that I have cited before is Texas. Now, Texas of all places. But Texas, in some jurisdictions, suspend, and in some jurisdictions don't. A good example of that is Dallas and Fort Worth. Now, these jurisdictions are right next to each other. Dallas still suspends driver's licenses for unpaid fines and fees. Fort Worth, on the other hand, does not. Fort Worth has actually seen an increase in the amount per case, money per case that they collect, which is $116, and Dallas still collects $113. So the practice of ending driver's license suspensions could actually help jurisdictions to increase their revenue rather than decrease their revenue. There are also many benefits to our state that ending this practice would offer. Personally, for residents who have their licenses suspended, they see the fact that they're not able to drive around. We talked about that earlier. It decreases their mobility. But Arizona has a program where they actually reinstated licenses for some residents who had their licenses suspended for unpaid traffic debt. And those folks said they saw an increase in their mobility. They saw an increase in the ability to drive their family members around. But I think one of the most important things is that they saw an increase in their employment and their income on an average of about $3,200 per year, up to $48,000 per year. These people who were in this program, and by the way, Phoenix reinstated only about 7,000 licenses in this program. So the benefits are significant. But one of the most significant benefits that Arizona has seen, Phoenix in particular, is an increase in their GDP and jobs. So we have data out of Arizona that says, as a result of just reinstating only these 7,000 licenses, that they saw an increase in their GDP of $149 million. They also saw an increase in their jobs per year. So I think with the benefit that we see from states that have ended this practice, is far outweighs what we see from not ending this practice. This practice, it just traps people in a cycle of poverty, as we mentioned, but it also has implications for the state. And so I think with that in mind, highlighting some of the benefits that states who have stopped suspending have seen as a result of that, I definitely think it's time that Nevada follow suit and stop suspending licenses for unpaid traffic debt. And with that, I just want to say thank you to Acting Chair Orenshaw for hearing this bill and committee members. And I want to thank the Majority Leader again for extending the opportunity to me to present with you today. If you have any questions for me, I am certainly open to that. So Chair Orenshaw, thank you.
Thank you very much. Thank you, Ms. Mosley. Thank you, Majority Leader. And certainly coming from Southern Nevada, being a native and growing up there, we've come a long way with our public transportation, but it's still a challenge. And I know where I live and where I work, I've mapped it out in terms of, there are days I said, well, why don't I just try to take the bus to work and not drive? it's better for the environment. And notwithstanding all the progress we've made on public transportation, I believe I'd still have 3 miles and 3 miles back, 3 miles each way, so 6 miles total, which it makes it kind of very difficult for people if they can't drive to be able to work, to be able to pay off that fine. And so I really appreciate the bill, Majority Leader, and thank you, Ms. Mosley. I believe we have a question from Senator Hansen.
Thanks, Vice Chair. Actually, I don't know, I caught some implicit bias in the comments. Texas, of all places. Now, I guess you could say that was a little bit of a biased comment, but all right. The problem we've got here is if you read the existing law that we're striking out, there it says in it, up to the judge, because if they willfully were avoiding payment, in other words, the judge has already taken into account the fact that some people are indigent and cannot afford to pay it. So we're striking, we're acting like the judges apparently just ignore that part of the law. Then if you can't pay it under current law, you have the opportunity to perform community service. And then the part we're striking out, if you fail to perform community service, nothing to do with dollars here, just simply showing up to pick up garbage on the side of the road or whatever, we're striking all that out of the law. So the concept, as Ms. Mosley said, simply because they cannot pay, simply isn't accurate. And then the other question I've got is, we're getting rid of section B there, and we're moving what's currently law C up into B. But C says, if the court, exact same language, if the court determines that the defendant has the ability to pay the amount due and is willfully avoiding payment, order the confinement of the defendant in the appropriate prison, jail, or detention. So while we are taking away the ability to use the driver's license as leverage, we're leaving in the law the ability to throw them in jail. So to me, this has some really critical flaws in the thinking here. These people are not just people that can't afford to pay it. They've already gone through that. They're then given community service. We're going to throw that out. And then we leave in the law the ability to throw them into jail for the same thing. So, Vice Chair, you want to tackle that, or Ms. Mosley, or whoever?
I think in my experience, just a point of privilege here, and then I'll pass it to whoever wants to answer it. Since the pandemic, I know that many of the clients, much of my experience has been that it's become difficult, if not impossible, to perform community service, to find places that are open right now. And now, of course, I hope things will get back to normal soon and that will change. But I know in the last little over a year, it's become very difficult finding, the community service organizations where someone can perform that community service open due to the problems we've all been facing with the pandemic. But as to the other questions, I'd pass it on either to the Majority Leader or to Ms. Mosley.
Well, Vice Chair, before you do, real quick on that point, there's no sunset in this new thing that when COVID is pushed back, that we go back to this system, okay? So even if currently there's an inability to perform community service, that's been in the law a long time. So I don't see COVID as a legitimate excuse to strike it out of the law completely and leave in place the ability to throw them in jail.
And thank you, Chair Orenshaw, through you, and to Senator Hansen. Thank you for the question, Senator Hansen.
When you go to Majority Leader, you can go direct to the Senator. You don't have to go through the Chair.
Thank you, Chair. Senator Hansen, certainly I think the idea that we're talking about Texas is that this seems to be characterized, this kind of law, right, seems to be characterized as something that's a little more progressive. And I don't think I view it that way. I think I see it as, well, how we're trying to leave certain things in the law and how we're not. And I think that, certainly in the Lone Star State, I think they definitely are not in for as many changes in the law in that regard. And so I think that was just a nod to the fact that this is happening across jurisdiction lines and without regard to whether or not it is a more progressive policy or not, whether or not this is something that is pro-government or anti-government. And so certainly did not mean to sort of imply anything untoward. So let me first say that. I think it's important, though, to draw this distinctions between the fact that we do have jurisdictions that are sometimes characterized differently, employing the same types of policies, and both jurisdictions seeing really positive results from that policy. I wanted to take just a minute to note a couple of things, because I do see your point about the language in the statute. I did have an opportunity to speak again with the courts of limited jurisdiction earlier today. And in fact, they have indicated that while the language seems to be here that it is permissive, how this actually functionally operates is that where there is merely an outstanding fine or fee, not that someone is not complying with other conditions that they've been asked to do. But when that happens, the suspension is automatic and must be done by the court. So they lack discretion in order to do that. So we're actually not having findings of this person has the ability to pay. That's assumed, the fact that a fee or fine was issued. So the court is not going into a fact-finding hearing or any sort of due process-based procedure in order to make that determination. Additionally, and I think what's important to note here, and the reason for the additional language being left in there about whether a defendant is simply not paying their fines and how that would practically work is in Las Vegas Justice Court, for example, they don't utilize this for things that are criminal in nature, right? So if somebody is charged with a battery, with a simple battery or a simple assault, typically what will happen if they're not just going to serve jail time, and if they're just going to serve jail time, then they're sentenced to jail, they serve that time, and that's the satisfaction of the sentence associated with that particular conviction or plea. If somebody, however, is, let's say, out of custody or is released from custody and says, hey, I'd like to plead guilty to this particular charge, or it's negotiated that way, they will plead guilty to the misdemeanor charge. They will be ordered sometimes to pay a fine. They will sometimes be ordered in lieu of that fine to do community service as sort of an either or. And maybe they might be assessed a condition to attend impulse control counseling in order to stay out of trouble so they can't pick up additional cases. And then they would have what we call a suspended sentence or an implied sentence for the court to issue contempt of court. And if there was a contempt of court order, that would be jail time. And the reason for that is because we have enforcement mechanisms for individuals who are satisfying their sentence outside of a jail setting. And there are lots of good reasons for why we want those things. Why we want to make sure there are stay out of trouble orders so they're not out committing additional crimes. Why we want to make sure they're doing community service or giving that option if they can't pay the fine. Where this really comes into play, because in those criminal cases, let's say they don't complete the community service, they don't pay the fine, or for example, they don't stay out of trouble, they pick up a new offense, or they don't complete their counseling, then the court can impose that suspended sentence, or they can impose contempt time and the person does time in jail in satisfaction of that. Where this particular provision comes into play, and this is specifically true amongst the justice courts, and so those courts of limited jurisdiction, is where people have traffic tickets, right? So you have a traffic ticket for speeding. You don't pay that. The court, because you have been assessed a fine, is assuming you have that fine to pay. You just can't pay the fine. There is an automatic provision that the courts then suspend that license. What that results in is that person now has not only the fine from the underlying traffic ticket, they also have now additional fines and fees in order to go to the DMV to actually reinstate their license. And in the meantime, that suspended license prohibits them, right, from driving. And I think to Senator Orenshaw's point, especially in Southern Nevada, and I grew up where at times we had transportation and at times we did not, or we didn't have reliable transportation. And when you don't have that, you don't have a vehicle that can get you to and from work, that makes it very difficult and very susceptible to job loss, right? Because you can't show up. And in a lot of those jobs for at-will employment, you're simply fired. And so that sort of perpetuates this, where really we're talking about things like traffic tickets. We're not talking about trying to remove the court's ability to enforce other provisions, like, for example, a suspended sentence, or, for example, a stay out of trouble order or other counseling or community service. So, and typically in practice, if it's something like community service that they're not doing, they're usually going to get that suspended sentence, not the suspension of a driver's license. And so we're trying to really get at that particular provision, and the way in which this law operates in practice is a little different than the statutory language, and those courts of limited jurisdiction find that gets forwarded to the DMV automatically.
All right, well, I thank you. That was a kind of drawn out way to, I still don't understand why we'd eliminate the community service portion of it. And I'm not sure your implicit bias against the state of Texas is not implicit bias. To call them less progressive, I would bet a lot of Texans would take offense at that. Anyway, look, the overall idea of the bill, I understand and I agree. Look, it doesn't make sense to take people's license away so they can't go to work to pay their fine. That makes sense. And the idea that you mentioned, where courts automatically assess the fine, I can understand that too. I'm thinking more of a situation where a judge or somebody comes and says, Your Honor, I'm guilty, but frankly, I'm unemployed at the moment. That typically doesn't happen in traffic court. So I see where you're going with this. So I'm not opposed to the concept. It does seem just sort of odd, though, to eliminate community service and the suspension after they've been given the opportunity by the courts. That's can't pay my fine. Well, then you'll go pick up garbage. Don't show up to pick up garbage, I'm going to suspend your license. And that's what the current law allows. And we think it's a mistake to remove it. But thank you, Madam. I got all the titles around here straight. Madam Majority Leader and Mr. Vice Chairman. Thank you.
Thank you, Senator Hansen. I have a question from Senator Settlemyre.
Thank you, Mr. Vice Chairman. I appreciate the opportunity to ask a question. Majority Leader, I'm just a little bit confused, but as you know, sometimes that happens with me. In that respect, will the court still have the jurisdictional ability to suspend driver's license based upon other criteria that are within Nevada law, such as graffiti citations, things of that nature?
Thank you, Senator Settlemyre, for the question. Nicole Canizaro, Senate District 6. Yes, we are not intending, and the provisions here are not intending to take away the ability for a driver's license to be suspended, for example, if there were, and the thing that comes to mind to me is something like a DUI. There are different provisions under those statutes where if somebody is not doing the things they would have to do there, then suspension of the license is a penalty to that. This is merely getting at those instances where we're talking about someone who cannot pay those fines and fees, and trying to ensure that we're not adding that on, and that we can look at different ways in order to assure the payment of fines and fees, because this, and I think Ms. Mosley talked about the data here, this is not something that is impacting or I guess supporting the idea that we're going to collect more on fines and fees simply because we suspend someone's license. Rather, we're seeing the exact opposite. So this is not intended to get at other instances where suspension of a driver's license would be appropriate, either for things like CDC license violations or DUIs, or where someone has so many points on their ticket that they are now somebody who has their driver's license suspended. But we're talking about those instances that deal really just with inability to pay.
So in that respect, again, it's just inability to pay. So just I'm going to get it on the record real quick. You're not going to be able to utilize in this particular change in law. So it will not prevent taking away someone's driver's license for collecting 12 or more demerits in a year, first or second DUI, street racing, driving without car insurance, graffiti citations, because I know numerous judges that use this as a tool, especially when dealing with youth offenders, to take away their driver's license due to graffiti violations. You will not be able to use this for falling behind on child support payments. So in other words, the court will still be able to say, no, we're taking away your driver's license because you're being a deadbeat parent. You're not going to be able to use this for failing to show up for traffic court. Third offense is securing a child in a car seat, perjuring oneself to DMV, habitual truancy, possessions of drug, alcohol, firearm utilization, none of this. This is only for situations where people were choosing not to pay. Sorry.
Fine. Take a sip of water. That was a long list. Thank you, Senator Settlemyre, for the question. Nicole Canizaro, Senate District 6. That is correct. That is our intention, is to get at those instances. Certainly, there are times where suspension of a driver's license makes sense. We're not trying to take away that ability entirely. We're just trying to ensure that what we're not doing is using it as a mechanism to try to enforce payment of fines and fees when we have statistical data that shows us that is ineffective, and where we have data that also shows that it just simply adds to what I think we've discussed today as that cycle of debt.
Appreciate that. I also look very forward to seeing your data once you collect it of how often this is being used. Thank you.
Thank you, Senator Settlemyre. Thank you, Majority Leader. Senator Harris.
Thank you, Senator Orenshaw. I don't have a question, just a quick comment. I absolutely love this bill. And it's mostly because I'm someone who has at some point received in the mail that suspension notice and felt that sinking feeling and frantically picked up my phone and tried to call every person I know to see if they could get me a ride to work that day in order to be able to figure it out, hopefully for the next days until you could figure out why it was suspended, which ticket maybe did you miss going to court, what fine weren't you caught up on, and having also the experience of maybe thinking about community service, but taking a look at the list and knowing that none of those days work with your days off at your job, where you have very little control over your schedule. And so trying to manage all of those emotions and how difficult that can be. I personally appreciate the bill. Thank you.
Thank you very much, Senator Harris. Members, any additional questions for the Majority Leader or Ms. Mosley? Okay, I don't see any additional questions. I'd like to go to support broadcasting. If there's anyone who wishes to speak in support of the measure, we're allotting 2 minutes per caller.
Thank you, Senator Orenshaw. We're currently on support testimony for Senate Bill 219. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Once again, we are currently on support testimony for SB 219. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Caller with the last 3 digits 841, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Majority Leader Canizaro, Vice Chair Orenshaw, members of the committee. My name is Lisa Rasmussen, Lisa Rasmussen. I'm here to testify in support today of this bill on behalf of NACJ. I think it's a great bill. It really does target the people who are too poor to be able to pay their fines and fees. And as everyone has pointed out, the consequence of that is often losing your job, which doesn't help pay the fines and fees. And it really doesn't target the people who should lose their license, which are DUI cases, reckless drivers, people who are dangerous drivers. So NACJ supports it, and I want to wish you all a really happy holiday weekend coming up. Thank you.
Thank you, caller. Caller with the last 3 digits 725, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you, Vice Chair Orenshaw and committee members. This is Nick Shepek, Nickshepak, on behalf of the ACLU of Nevada. We want to thank Majority Leader Canizaro for bringing this bill. This is a popular idea this session with a similar piece of legislation working its way through the Assembly. We welcome all the interest in this area. The majority of traffic violations that lead to traffic debt are debt-based violations, such as not being able to pay your registration on time, or not being able to fix a taillight right away. The fines and fees from these violations can be more than a person can afford. In turn, they fail to pay the fee in the allotted time and lose their license. As Senator Orenshaw stated, public transportation is problematic even in our largest city, and is almost non-existent in many of our rural communities. If the only way people can get to work is drive, they often will. If they don't have a license, that means they're driving uninsured. This is a major public safety issue. By suspending the licenses of the most vulnerable Nevadans, we are ensuring they remain vulnerable. These people are often single parents who have the responsibility to transport their children, and a license is necessary to do that. There are multitudes of ways to ensure that civil penalties are paid. Hobbling a person's ability to move freely about the area in which they live is a wrong-headed policy. We live in a state where driving is necessary for many. Our laws should take that into account. We should only suspend driver's license if having that license poses a safety risk to the community. Punishing poverty always leads to more poverty. It's that simple. We urge you to support this bill, and thank you for your time.
Thank you, caller. Caller with the last three digits, 611. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair, members of the Senate Judiciary Committee. My name is John Piro, John Piro, from the Clark County Public Defender's Office. I'd like to thank the Majority Leader for bringing this bill forward and for Lisa Mosley for presenting this bill. This is a good measure that can help people climb out of the holes that they sometimes find themselves in financially. I have worked at bench warrant quashing clinics where I've seen a traffic ticket ruin somebody's life. And that sounds unrealistic, but it is realistic. The person gets a traffic ticket, their license gets suspended. They can't pay the fines, and eventually they get arrested on a bench warrant. They're placed in jail for a few days. They wind up losing their job because they live paycheck to paycheck. They lose their housing, and it takes an enormous amount of effort to climb out of that hole. As somebody who lived paycheck to paycheck, even after coming out of the Army and going to college, where any one small thing could have set me back crazy amounts, or even growing up the way I did, where any one small thing could have sent my family back for months at a time. This is a great measure that can help a lot of people, and I urge the committee to support the passage of SB 219. Thank you.
Thank you, caller. And as a brief reminder, we're currently on support testimony for Senate Bill 219. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue. And Senator Orenshaw, at this time, there are no more callers to give support testimony.
Thank you very much. Broadcasting, if we can now go to anyone who wishes to testify in opposition to Senate Bill 219, we're allotting 2 minutes per caller.
Thank you, Senator. If you'd like to provide opposition testimony on SB 219, please press star 9 now to take your place in the queue. Once again, to give opposition testimony on Senate Bill 219, please press star 9 now to take your place in the queue. And Senator, there are no callers to give opposition testimony at this time.
Thank you. Broadcasting, I'd like to go to anyone who wishes to speak neutral to the measure. 2 minutes per caller.
Thank you, Senator Orenshaw. To provide neutral testimony on SB 219, please press star 9 now to take your place in the queue. Once again, to provide neutral testimony on Senate Bill 219, please press star 9 now to take your place in the queue. Caller with the last three digits, 101. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Yes, this is Sean Sever, S-E-A-N-S-E-V-E-R for the record. I'm from the DMV. Hello, Acting Chair and committee members. I'd like to thank the Majority Leader for meeting with us and hearing our fiscal concerns about this bill. We are neutral on it and understand the purpose. However, we did submit a fiscal note on the bill as written, which basically says we're willing to absorb the programming costs that this bill would create for us, which are basically IT changes we have to make to our system. However, there is a large revenue impact to the DMV with this bill. And as many of you, have you seen the people standing outside our offices waiting to get in? The DMV is also suffering right now. Particularly with our revenue due to the pandemic. We are making budget cuts and not filling positions, and we appreciate the Majority Leader acknowledging this as well. But we are willing to work with the Majority Leader to see if there are ways we can lessen the impact. We are also looking at seeing how other state DMVs are handling this issue, because there are similar situations in other states. And thank you all for your time today.
Thank you, caller. A brief reminder, we're currently on neutral testimony for Senate Bill 219. If you've just joined us and would like to provide neutral testimony at this time, please press star 9 now to take your place in the queue. And Senator Orenshaw, there are no more callers to give neutral testimony at this time.
Thank you very much, broadcast. I'd like to bring it back to the Majority Leader and Ms. Mosley. Any closing comments you'd like to make?
Thank you, Vice Chair Orenshaw. This is Lisa Mosley, State Director for Fines and Fees Justice Center. I want to again thank the committee and everyone for hearing this bill and considering it for support. I would like to offer also to Senator Hansen, if I may, why I characterize Texas that way, and no bias toward Texas. It's just interesting that in discussions about this particular practice, I'm often met with surprise at the fact that Texas has been out front on ending this practice. And so that's why I said that. No shade to Texas. I have lots of family members in Texas and look forward to visiting them once we are able to again. I also want to point out that with this legislation, will just give people an opportunity to be able to live and to support their families. As the Majority Leader had mentioned earlier, people who experience license being suspended, they're not able to drive themselves around. They're not able to work. They're not able to support themselves. And ending that practice would offer a benefit to our state in the form of people being able to go back to work, people being able to maintain work, and people being able to support themselves and their families, and possibly in reliance on things like state-supported things like food stamps or public assistance. And so I think this legislation will go a very long way and not only building up self-esteem for people who have experiences, but also supporting our state and helping us to increase revenue in some cases, and just to see, just to bring some relief to people. So I just wanted to point that out. And again, to just say thank you for hearing this bill.
Thank you very much, Ms. Mosley. And Majority Leader, any closing comments you'd like to make?
I think Ms. Mosley did a great job of summing it up, and I thank her very much for not only her time here today and her testimony, but her dedication and work in this area, because I think it's important work. And just want to thank the committee and the senators for their questions, and of course always love being in front of the Judiciary Committee. So thanks for having me.
Thank you very much for presenting. We will now close the hearing on Senate Bill 219. And the last item on our agenda is public comment. Broadcasting, if you would open up the public comment line, we are allotting 2 minutes per caller.
Yes, thank you, Senator Orenshaw. We're currently on public comment this afternoon. If you'd like to provide public comment at this time, please press star 9 now to take your place in the queue. Once again, to give public comment at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 556. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIEGRANT. Excuse me. The idea there is a war on police is false propaganda, and the idea of the thin blue line is indoctrination. The inability to acknowledge shortcomings and being in denial of them when it comes to law enforcement is telling. The saying is, one bad apple spoils the bunch. Nicholas Farah died in a restraint chair in less than 2 minutes. My brother Thomas Purdy was hogtied for 40 plus minutes and asphyxiated while hogtied. Justin Thompson was asphyxiated by washout deputies. Nico Smith was asphyxiated by them. Christopher Talencon was asphyxiated by Sparks PD. Micah Abbey was asphyxiated by Reno PD. LVM PD asphyxiated Byron Williams, Tashi Brown, Roy Anthony Scott, Dustin James Boone, Darrell Hicks. It's time for Nevada to acknowledge their own George Floyd. Until we change the attitudes of many, as witnessed today during the hearing, laws will do no good. Chances are, if law enforcement aren't opposing a bill, it really won't hold them accountable anyway, so you shouldn't be worried about it. There is no fabrication in this data. Nevada has 395 community members killed during interactions with police since the year 2000 per fatalencounters.org. That number does not include in custody deaths such as Nico Smith and Justin Thompson. Please support bills that promote transparency and accountability. Thank you. Have a nice weekend.
Thank you, caller. And with that, Senator Orenshaw, there are no more callers to give public comment at this time.
Thank you, broadcasting, and thank you to all the senators, all the staff. Thanks for all your help to make this meeting happen today, and we are adjourned.